website. An issue explicitly left open in the two foregoing decisions relates to the standard of proof which has to be applied to Internet disclosures. Unlike conventional paper publications, Internet disclosures present specific difficulties. There may have been modifications in the course of time without being reliably traceable. In the European case law, there is, or there was, a sustained uncertainty in respect of proof requirements for Internet disclosures. Some boards applied a very high standard beyond any reasonable doubt or up to the hilt. Some others refer to a balance of probabilities. Now, in a very recent case of 2014, Board 356 was a French case, T286 of 2010. In the European Patent Office there are 3 official languages, so the applicant can choose the language. It was a French applicant. The board declared any proof requirements for Internet disclosures to have no legal basis. The common standard of proof applies, according to which the existence of a prior publication has to be established by evaluating the probabilities according to the circumstances of the case under the premise of, and thus the important expression, free evaluation of evidence. In the present case, there have been 2 Internet disclosures, A9 and A10. A9 was retrievable at the same Internet address to this day and prima facie resulted from a known and reliable source of information. Hence, its date of publication seemed highly probable. Now, with respect to A10, the URL showed that it had to be assumed that this document had been archived by the Internet Archive on a date before the priority date of the patenting suit. Although the board did not exclude that doubts about individual entries of the archive might arise, it believed that the archive itself sufficiently guaranteed the presumption of a reliable and trustworthy source of information. Therefore, a general allegation of lack of reliability of the Internet Archive was not sufficient for questioning the date of public access to an archived document. So now let me come to my next topic, mathematical methods. Can a different mathematical approach establish novelty? Stefan already mentioned the fact that mathematics can make a technical contribution, and this was very important in this case, T2050 of 07 by Board 3308, DNA mixture analysis Berlin from 2030. This is a case related to biotechnology. It concerned a method and system for analyzing a DNA sample that contains genetic material from at least 2 individuals and then there were certain steps, amplifying steps, detecting steps, resolving steps. This method or such an analysis plays an important role in forensic proceedings, in which, of course, the reliability of genotype determination methods is of highest importance. The resolution into the component genotypes, according to the last step, was accomplished by solving a system of coupled linear equations for the relevant loci, individuals, and alleles. Now, a method of this kind, an almost identical method, was known from an earlier European patent application of the same applicant. This earlier application is under the European Patent Convention only only relevant for prior art for the requirement of novelty. The claim method was distinguished from the earlier application by details of the mathematical treatment of the data in the resolution step. The only difference was the addition of two features relating to mathematical steps of errors computation and evaluation. So some kind of simply sound standard deviation or things like that. Was the claim method new over the applicant's earlier application by adding these two mathematical steps? Now we have seen the claim method was patent eligible for the mere reason that the amplification and quantifying steps were performed using dedicated laboratory equipment. That means they used technical means and was therefore not devoid of technical character and therefore in principle patent eligible. So the first hurdle mentioned by Stefan was overcome. With respect to the mathematical steps, the distinguishing features, the question arises, are those features of non-technical nature? Mathematical methods, as we have seen, are excluded as such in Europe, or can they be seen to make a technical contribution? Then the second hurdle might be overcome. Now, both distinguishing features aim at ascertaining the reliability of the DNA analysis of samples containing genetic material from two or more individuals, and thus resulted in a quantitative estimate of the quality of the solution. The board therefore found that the distinguishing features constituted a means for improving the confidence of the genotype estimate of the quantitative method analysis of the earlier application, and therefore considered that the distinguishing features contributed to the technical character and thus had to be taken into account when assessing novelty. The board concluded that the claimed method was in fact new, was only distinguished by mathematical steps. Now, my last topic is signals. Are signals patent eligible subject matter in Europe? This is interesting if you look into the United States. There is a well-known decision from the Federal Circuit in Ray Petrus ACM Leuten of 2007, and this decision was more referred to and more or less confirmed in a more recent decision by the Federal Circuit, Digitech Image Technologies versus Electronics for Imaging and others in 2014. The Federal Circuit said in Leuten, the claims on appeal cover transitory electrical and electromagnetic signals propagating through some medium such as wires, air, or vacuum. Those types of signals are not encompassed by any of the four enumerated statutory categories: process, machine, manufacture, or composition of matter. And there was a dissenting opinion by Judge Lin, who thought that signals might be a modern form of manufacture. And the applicant, it was in fact Philips, they filed a request for an en banc reconsideration by the Federal Circuit. This request was denied. Now we had in Europe a case in some respects similar to that case, is T533 of 09 by Board 3401, 2014. This case concerned a method of defibrillating a patient suffering from a heart attack. And this method used in such a case, you have to apply high energy, high voltage to the patient. and this voltage is created by discharging a capacitor. The signal of the capacitor, the discharge signal, as can be seen in figure 2, is chopped up into pulses with breaks in between. Now, since the electric voltage is gradually exponentially decreasing in a capacitor discharge, we have a problem that the pulses at the very beginning may be too high to be applied, the energy too strong for the patient, and in the course of time it will have no effect anymore because the pulse height has been reduced considerably. The invention now proposed to modify the breaks between the pulses. So the length of the breaks decreases correspondingly in accordance with the height of the pulses, so that the energy delivered to the patient remains more or less stable. This is a straight line you can see in figure 4. This application was refused by the examining division for lack of novelty, but they added as an additional remark, a train of elementary pulses constitutes a physical phenomenon which is not sufficiently tangible for being considered as a product or a process. Now, this may remind you of the US argument in Neuton. The board found the term tangible is ambiguous. It could be construed very broadly, meaning any measurable or detectable aspect, or more restricted in the sense of material. Now, the requirement of a tangible in the sense of material character for inventions is foreign to the GIPC. The legislators intended to retain a fairly broad definition of invention, and thereby deliberately abstained from the formulation of any requirements concerning the category an invention must belong to. The concept of invention pursuant to VII has therefore to be distinguished from that of other patent systems, in particular the US system. Pursuant to a decision of the Enlarged Board of Appeal G288, friction-reducing additive mobile oil 3, basically two different types of claims exist. A claim to a physical entity, for instance a product or apparatus, and a claim to a physical activity, for instance a method, process, or use. The claimed pulse train was of concrete nature insofar as it resulted from the modulation of an electrical signal and was susceptible to measurement at any time. Such a signal, in fact, fell within the definition of physical entity given by G288. Therefore, the nature of the claimed subject matter was not absolute to its patentability. Hence, it appears safe to assume that signals are not generally excluded from patentability of the VIC. In particular, a transitory, propagating character is not an exclusion criteria. If a signal reflects the properties of the technical system in which it occurs, by being particularly structured or formatted, and thus is adapted to and can be detected by technical means, it should be considered. Thank you for your attention.